Well, good evening, everybody, and welcome back. It's so nice to see everybody. Thank you very much for attending the second and final session of Inside the Courts, and we are already working on what we will be presenting for you next year, and we hope you will be able to come back and see us. But today we're going to be talking about county court, county criminals specifically. I think last year we talked a little bit about evictions and things like that, and that's county civil. Today we're going to be hearing from Judge Gabrielle Sanders-Morency, who's to my left, and about what goes on in the people's court when it comes to criminal matters. Okay, let me tell you a little bit about Judge Sanders-Morency. I may slip and call her Gabby. It's no disrespect to her, but she is such a Gabby. We're just going to call her Judge Gabby or Gabby. But as you can tell, she's still quite young. She was elected to the county bench in Osceola County. And incidentally, this is the first time we've ever had an Osceola County judge speak at Inside the Courts. As we've mentioned before, the Ninth Circuit is Orange County and Osceola County. It's a big geographic region. Judge Sanders-Morency was elected in 2018 as a county court judge. So she's driven all the way from Kissimmee or St. Cloud to be here with us today. She was in fact the first Haitian-born person to be elected judge in Osceola County. She has served in both civil and criminal divisions. Her journey from Haiti to here is fascinating. I'm going to touch on it briefly, but she can give you much more detail. But it is fascinating. I believe her mother emigrated here when she was very young, and she and her brother lived with her grandmother, her mother's mom, in Haiti after being born in Jacmel, Haiti, on the southern coast of Haiti in 1983. I've just given away her age, okay? But it's fascinating. Her mother was a trained nurse in Haiti. Comes over here, presumably looking for a better life for her children, has to get re-educated in South Florida, becomes a registered nurse, I believe, here in Florida, saves up enough money to bring Gabby and her brother here to the United States in Florida when she was, I believe, 7 years old. Learning a new language, trying to fit in, all of those things that go with coming to a new place, and she fit in quite well. And we're very pleased to have her here. She was educated at the University of South Florida, undergrad degree. Go Bull. That was a question last week, a mascot, but that one's too easy, the USF Bulls. Law school at Florida A&M, the what? The Rattlers, yeah, Florida A&M Rattlers. English literature and, English literature and American literature major. For some reason, she loves Shakespeare. Which is fascinating. Again, law degree at Florida A&M. She has been honored by numerous organizations. In 2021, for example, Judge Sanders-Morency was honored for public service by the Gwen S. Cherry Black Women's Lawyers Association. She's been recognized for distinguished judicial service from the Florida Council on Crime and Delinquency. That was in 2020. She's also recognized as a distinguished alumna from the Florida A&M University. She has served in criminal and civil divisions, and she's just the person to talk to us about county criminal. Please help me welcome Judge Gabby. Okay.
Good evening, everyone. Let me open my bag of candy. It's more enticing this way. So they've informed me that I have to stay here and I can't walk around as much, which is going to be kind of difficult for me because I am a prior prosecutor and I feel like this contains me way too much. So I will do my best. All right. So as Judge Egan indicated, I am a Osceola County judge. I absolutely love being a county judge. I get to be with the people, the citizens of my community. It's not the worst of the worst. As a prosecutor, I dealt with the worst of the worst. So I just wanted to deal with people that may have made a mistake, right? But they have to be held accountable, and my job is to hold them accountable, but also give them some grace if needed. And I get to talk with a lot of young attorneys. I was a trial attorney for 9.5 years before taking the bench, so I kind of know about having a super heavy caseload. So helping them become better attorneys. So again, I absolutely love being a county judge, and thank you for having me. I am super happy to be here, and I will be talking to you all about the criminal justice system. So let's start. Let me see if I know how to work this. All right. So, things you need to know about our criminal justice system. All right. So, how many of you all have ever heard of reasonable suspicion? Right? Reasonable suspicion. Right? Who can tell me if that is a requirement that the police would need in order to stop you? Yes, right? Okay. So let's talk about it some more. Not used to this high-tech technology. Let's see. I got it right the first time. All right, see the cool eye? Yeah. All right, so again, a lot of people have already said this that I heard. Before police can detain you, you must have a reasonable belief that a crime, a criminal act has occurred, okay? So it's either being committed, it's about to be committed, or it's actually happens in front of the police officer's eyes, right? So a lot of the time, we get cases where there's a speed limit issue, right? Someone speeding, or maybe a tag light is out, okay? That's a reasonable suspicion for a traffic offense. Now, traffic offenses can be civil or criminal, okay? It depends on the statute. But let me just give you a hypothetical. There's a person driving down OBT and the tag light is out, okay? So the officer has some suspicion of a civil infraction, so they're gonna conduct a stop, right? So they conduct the stop and they approach the driver. Upon approaching the driver, guess what? They smell odor of marijuana. All right? So now this simple traffic infraction has now turned into what? A criminal offense. All right. I'm going to give candy out to everyone. You all just pass it out. So,
You certainly can, Judge.
all right, so I'm sorry. I'm so sorry.
No, you certainly can.
Okay, so it's now a criminal act, right? So he has reason, he or she, the police officer, has reason to believe that someone is in possession of cannabis, all right? Now, what do you think this police officer does? What's your name? Glenn, Mr. Glenn, what do you think the police officer does? Do you think the police officer will request, here you go, will request that the driver step out of their vehicle, Mr. Glenn? Do you think that's able to happen? It depends on the cop, right? Some police officers might say, hey, you can go. Did you get candy? Yes, good. Some police officers might say, yeah, they can stay in the car or perhaps get out of the car, right? No candy? You sure? If you change your mind, you let me know. You want some candy? All right, my friend, here. All right, everyone got some candy, right? All right, wake you all up a little bit. Miss Camera Lady. Candy. All right, so I'm gonna go back to my area. The police officer, let's just say the police officer sees thank you, the cannabis bunt, right? And then they see bags of cannabis. What do you think is gonna happen next? All right, they might get the dogs, probably don't need the dogs because guess what? Odor of cannabis is probably cannabis, right? So, now the police has what? What's our next step? So the reasonable suspicion stemmed from what? A traffic infraction, right? And when he approached, odor of cannabis, was trying to see What's going on? Should I let him stay in the car? Maybe I should ask him to get out. What do you think happens next? Probable cause. All right, I'm probably gonna need help. What do you all think about probable cause? What do you think you need? There we go. It tells you. So probable cause is a requirement found in the Fourth Amendment. Okay? That is the only way the police officer can arrest someone. They have to find that there is probable cause, that there's an actual reason to arrest that person, that this is the person that committed the crime, this is the person in our hypothetical that was in possession of cannabis. Whether it's a misdemeanor amount, which would be under 20 grams, this is over, it's a felony, okay? So, who do you all, I'm just gonna pick on you, what's your name? All right, so probable cause, let's just say that person, our driver in our scenario, okay, gets arrested. Do you think there's someone that reviews the probable cause?
I'm not sure.
Okay, and that's just fine. Okay, anyone can tell me if someone reviews probable cause? No, you think someone can just arrest and? So I get a little bit half, okay, perfect. That's exactly why we're here. Yes, just because a police officer arrests you on OBT doesn't mean you just go to jail, no one reviews what the police officer has actually done, right? Who do you think reviews that probable cause affidavit, which is the charging document? Okay, I'm hearing prosecutor, DA, very, very good responses. My friend here, what is your name? I'm Martha. Martha. Absolutely, the judge does that. All right. Initial appearances. So, when someone, our driver, gets arrested for possession of cannabis, okay, they have 24 hours to see me. It just so happened last week I had initial appearances. So, they will give me a charging affidavit. I have to review the four corners of the charging affidavit, which will tell me on such and such date, I saw a gray Toyota driving on OBT, had a broken tail light. I conducted a stop upon approaching the vehicle. I smelled the odor of cannabis. Through the clear glass window, I was able to, observe the bags of cannabis. And based upon that, I made my arrest, okay? So, reasonable suspicion. I'm short, but hopefully y'all can see me. Reasonable suspicion. Probable cause, okay? So my job as the initial appearance judge is to review the arrest warrant, if they were arrested, and then a prior judge reviewed that, I will issue a bond, but we'll get to that. But if that person's arrested, I and my other colleagues, if it's our duty, we will, because we rotate, but we'll get to that too, we will review the charging affidavit. I will determine if I find probable cause. If I find probable cause and they are entitled to a bond, I will give them a bond. If not, then I'll either give the state 24 hours. If I don't find probable cause, maybe they can find probable cause. Sometimes they can't. Or I'll do an ROR, which means release on their own recognizance. So no monetary bond is issued. They just got to stay out of trouble. Okay? So this just goes through what I do. So not only do I review the actual charging affidavit for an arrest, but sometimes in the middle of the night, we will get warrants. So as a judge, my duty once a year, it's to be on call for 7 days, 24 hours. And I get warrants from both Orange and Osceola County. Based upon the warrant, I will go ahead and find probable cause. and I will sign off on it, and they will execute the arrest warrant, which means that they will then go find the person and arrest them, okay? I also review violation of probation warrants. Those are usually zero bond, which means they can't get out until they see the trial judge. So let me go to my next slide. So let's talk about pretrial release. This is a little sticky, and it's changed as of January 1 of this year. So the way it typically works, when I am the initial appearance judge, I will get a document from pretrial release. Pretrial release is a program where you will directly report to someone, okay? They might drug test you. They might check your, premises to make sure that you don't engage any illegal conduct. You're not talking to anyone that's a felon and things of that nature. And typically when I issue a bond, there's always conditions, okay? For instance, let's use our hypothetical. Our driver has been charged with possession of cannabis. Since I'm a county judge, we're just gonna make it under 20 grams, okay? That is a first-degree misdemeanor. That means that the maximum penalties is 1 year supervised probation or 1 year in jail, up to $500 fine, okay? So I've reviewed the charging affidavit, and I do find probable cause within the four corners of this document, okay? Who can tell me if this driver is entitled to a bond? Anyone? Don't be shy. I don't know that. Remember, I'm the IA judge. I only have that document in front of me. Sometimes the state might be really, really good and tell me that they have prior criminal history. That doesn't typically happen. So we're on the surface. I don't know anything but what I've been given by the arresting agency. We'll get to that. That's good, but we'll get to that. So, possession of cannabis under 20 grams, first-degree misdemeanor. He's entitled to a bond. Absolutely, okay? So I typically will issue maybe between $500 to $1,000 bond, okay? Just depending on the facts of the case. My conditions of the bond would be not to consume or possess any illegal narcotics. And what I will tell on the record to the PTR officer is this will be a monetary bond with PTR conditions, and you're going to do a random urinalysis. So I want him drug tested or her drug tested, okay? So when that person's able to bond out, that's 10% of the 500, when they're able to bond out, they're just not out there living their best lives, okay? They have to go ahead and see a PTR officer, and they will be randomly drug tested, okay? Let's switch up the scenario a little bit. Let's just say that this is an arrest warrant, okay? Remember what I said, the arrest warrant, I can review that at my house if I'm the on-duty judge. I find PC, they go out and they arrest the suspect. He gets to see me in IAs, right? So when he sees me in initial, I'm sorry, I'm using acronyms. When he sees me in initial appearance, he or she, I will say, probable cause has already been found, okay? Now, this is where it gets tricky. Do you all think that this person is entitled to a bond at initial appearances? This is battery, domestic violence. Okay, very good. So, as the judge that's reviewing the warrant, I cannot issue. Let me do it this way, it'll be easier to understand. So you have an e-duty judge and initial appearance judge, okay? So in January, I was the e-duty judge, which means that I reviewed all the arrest warrants for both counties. So we're in January, okay? So when I get it, I'm reviewing it already to find probable cause. But I'm gonna say zero bond. And on my little sheet, I'm gonna say zero bond to be issued by the initial appearance judge, okay? And the reason why I do that is because there's certain crimes that the e-duty judge cannot set a bond, okay? And that's under the pretrial detention statute, okay? And that law just passed in January. We'll get into certain crimes that falls under that. But since we're in county court, I can tell you that battery, domestic violence, if someone gets arrested, okay, through an arrest warrant or maybe day of, okay, they cannot be given a bond until they see the initial appearance judge. That gives an opportunity for the victim to be heard. So perhaps I don't know certain information. Maybe there's weapons in the home. Maybe the victim does not want to have contact. There's certain things I need to know. Perhaps they have children and the victim does not want this individual to have contact with the child. That's why it's very important that we hold this person at zero bond until initial appearances and I can get more information, okay? So, we're at initial appearance and I get this quite often. Judge, no criminal history, no objections to direct PTR, okay? Direct PTR means there's no monetary conditions, okay? He doesn't have to post anything. All he has to do is check in with PTR. Who thinks I'm gonna be okay with that? By a show of hands. You think I'm gonna be okay with that? No, right? So my response is, thank you so much. However, that's denied, and your bond is with PTR conditions. And normally the PTR conditions will be a no contact with the victim. That's during the pendency of the criminal case, okay? So no contact, no return to the home. You have to maintain a separate residence. I always add you have to maintain a separate residence because domestic cases are tricky and victims change their minds and they do go back to their attacker, their abuser. So if I put maintain a separate residence, even if the trial judge changes my no contact to no hostile contact, there's also that condition, maintain a separate residence, so you all can have contact, you can't live together. Okay, so that's kind of a way that I, as a judge, can protect the victim as much as I can, okay? And I also say no possession of any weapons or firearms. So that way, God forbid anything happens, I know that there's an order out there that says he or she cannot possess any weapons or firearms because they have this domestic battery pending, okay? So now PTR can get a little crazy as far as conditions, but I want to keep it as simple as possible. You can have direct PTR, yes, but I can't speak for every judge. I can only speak for myself. I only do direct PTR for maybe a trespassing on a property, maybe, or your county ordinance case, like urinating in public, something like that. So I don't typically do direct PTR, but every judge is different, okay? I typically will do a bond with conditions. The only time you will ever hear someone's released on their own recognizance is if a judge does not find what? Yes, good class, all right. So we talked about the new pretrial detention statute, and there is a ton of, it's working up here, all right. So I'm gonna read this to you. So dangerous crimes may not be released on a non-monetary pretrial release at first appearance if the court finds probable cause for the dangerous crime. And I've listed all of the dangerous crimes. There's arson, aggravated assault with a weapon, there's aggravated battery, illegal use of explosives, child abuse or aggravated child abuse, homicides, of course, kidnapping, aircraft piracy, abuse of elderly, let's see, yes, all right, human trafficking, and it's really big in Central Florida. So there's no bonds for that, written threats to kill, trafficking controlled substances. So now that's different. So trafficking, normally when I would review a arrest warrant or charging document, the bonds will typically start at $50,000, $100,000 and move up. So I would typically be able to issue a bond. Now, the legislator says, absolutely not. There is no bond until you see the initial appearance, judge. And guess what? Even when you see me, the state will say, Judge, I would like to file a pretrial detention motion. What that means is this person is dangerous to the community. And we plan to show you, Judge, through an evidentiary hearing that our case is a good one, number one, and we can prove that this person was trafficking, let's just say cocaine or methamphetamine or something like that. We need to keep this person off the streets, so he or she needs to be held at zero bonds until trial, okay? That can happen with our battery, domestic violence cases, okay? It can happen with actually all domestic cases. It can happen with our homicides, and now it can happen with our trafficking. Who have ever heard of Marcy's Law? Oh, good. So Marcy's Law was something enacted in 2018. And there's quite a few things that you have a right to do as a victim. I think one of the most important things I can tell you as a victim, your information, your private information will be redacted from the arrest warrant or any charging document. When the police officers sends their information to the clerk of court, before they upload it, it's redacted, and that's because of Marcy's. Another cool thing is, I used to be a homicide prosecutor. A lot of my survivors, my families, they would get really upset saying, why is the case taking so long, right? With every case comes its challenges. There's depositions that needs to be conducted. You have to kind of share information, whatever information the state has, you have to give it to defense. And unfortunately, it just takes a really long time, right? But under Marcy's, you can advance trial. What that means is, let's just say this homicide case has been pending for 2 years. You can have your advocate, your lawyer, put in a motion and advance the trial. I've not heard of that happening, but it can happen. Okay? Does anyone have any questions? I want to take questions on this because, yes, ma'am. Just the delay of it all. The fact that it's been pending for so long. And you know, I can tell you as a former prosecutor, you want to make sure that you cross all your T's and dot all of your I's because you don't want something to come back on appeal. And then that's worse, right? Because the family would never get closure because this case is going on and on. So even though under Marcy's you have that right, I don't think a lot of family members are willing to risk that. You know, you want to make sure that everything is done and it's done perfectly and it's done right through the trial proceedings. So you have that right, but I don't think it's come to that. But good question. Anyone else? I can just read. I know that it's a little small. So you have the right within the judicial process to be reasonably protected from the accused and any person acting on behalf of the accused. You have the right to have your safety and welfare and that of your family considered when bail and conditions of pretrial release are set. So when I have initial appearances, I do let family members come. I do let victims come and I say, hey, don't tell me anything about the facts of the case, but I do want to know, how do you feel about this bond amount? How do you feel about these conditions? Would you like me to impose a certain condition? How do you feel about this person having contact with the children? Do you want supervised contact? Do you want unsupervised contact? So things of that nature. You have the right to prevent the disclosure of information or records that could be used to locate or harass the victim or the victim's family, or which could disclose confidential or privileged information of the victim. That's what we talked about. When the police officers take the report, they'll take your name and things like that. That will all be redacted. Let's see. You have the right to request the opportunity to be present at all public proceedings involving the criminal conduct, including but not limited to trials, pleas, sentencing, or adjudication. So I've had victims come in at sentencing and say to the judge whether they're happy with the plea offer or not happy. And it's just not victims, but it's the victim's family, the surviving family members. So as a victim, you literally can participate in every part of the actual trial. Also, you get a victim advocate. Now, you can hire your own, but the state attorney's office does provide victim advocates to surviving families as well as the victims. And you have the right to request to confer with the prosecuting attorney, again, concerning any pleas and agreements. Right. All right, so that's fun stuff. All right, so let's go back to our original hypothetical where the driver gets stopped for the broken tail light, and the police officer says, all right, I smell this odor of cannabis, and then finds the baggies. If someone gets arrested and they go through what? I'm testing you all. What happens when someone gets arrested? Initial appearance, right? And if there's probable cause and they're entitled to a bond, who will actually give them that bond amount? The judge. Very good. If that individual is not able to bond out for whatever reason, the next step is a jail arraignment, in custody arraignments, okay? As a county court judge, we have jail arraignments every Thursday. Don't know about Orange County, but I will assume it's once a week as well. That's for felony as well as county. At the arraignment, we tell them what the formal charges are. So, even though this case may have come through and it could have been a misdemeanor, a first degree, guess what? At arraignments, it could change. They can add charges. So, you know how we started with that possession of cannabis under 20 grams? Guess what? My officer found out that his license was suspended, so now he has another charge, driving while license suspended, okay? And guess what? Picked up some more charges. Not only did we find out it was driving while license suspended, but they tagged on possession of, well, we have marijuana already. What do you think? Paraphernalia, yes, because the baggies. Excellent class, excellent class. So we went from one charge to now 3 separate counts. So that arraignment will tell you what the formal charges are, okay? Now, let's just say you don't get arrested, okay? Police officers having a good day. They're about to get off their shift. Hey, here's this NTA. NTA means notice to appear. So if you don't get arrested on scene, you will get a notice to appear, and the clerk will give you your date for an arraignment. Okay. Now, as a county judge, I do arraignments every single day, Monday through Friday, and it's usually 50 per day. Okay, Fridays are my worst, so they tend to give 75. I'm not quite sure what happens on Fridays. I'm like, it's supposed to be like a easy day. But we do arraignments as well as the felony criminal judges. We do arraignments every single day. So once a week, we're dealing with the inmates who are still in custody for whatever reason, can't bond out. And then for those that don't get arrested on scene, they will come see us and we will tell them what the formal charges are. And the formal charges come from who? The state, absolutely. All right, I just threw this in since we were talking about arraignments. So at arraignments, once I tell folks what the charges are, so our guy has possession of cannabis under 20 grams, possession of drug paraphernalia, and also driving while license suspended. Sir, these are your formal charges. How do you plead? I plead not guilty. Sir, what are you going to do about getting a lawyer? Oh, judge, I'm not working at this time. I lost my job. What do you think happens next? Exactly. He or she needs to do the paperwork to see if I can appoint a public defender, and it's based upon your finances. So sometimes they are above guidelines, and I'm like, you might not think you make too much, but this says you make too much, so you need to get a private attorney, and quickly. I will give them a pre-trial conference date, and that basically is a date where they will appear in front of me with their attorney, and I need to figure out what we're gonna do. I say fish or cut bait. That's what I always tell my attorneys, right? And then I see you're looking like, what? I do, because we have heavy caseloads, right? And I want everyone to be prepared, but I also have a job to do. I have to move my docket along, right? So is your client going to be taking a plea from the state, or are you going to reject this plea offer? And if you're going to reject this plea offer, are you ready for trial? I typically hear, no, judge, we're waiting on discovery. That means information from the state. We're not ready. Can I get a continuance? Okay? I might say yes. I might say no. But let's just say for this hypothetical, I say yes, I'll grant a continuance to the following pre-trial, okay? If I grant a continuance, have you all ever heard of speedy trial? Yes. So if I grant this continuance, who thinks the defendant waives his speedy trial? By show of hands. Yes, head nods, yes. They waive speedy trial. So let me just give you a quick little lecture. So in a county criminal case, speedy trial is 90 days. Okay, start to finish, I got 90 days, okay? If it doesn't happen, then they can file a demand, notice of expiration, and we're gonna do the trial, but I'm not gonna go into that. So that's 90 days. If I grant the continuance, that's waiving their speedy trial, which means that potentially this trial will go past the 90 days, okay? Now, for circuit, can anyone tell me how many days they get? Yes, ma'am. Oh, you know what? The criminal defense attorneys want that. But it's 175 days, but you're very close. 175 days, that's what circuit criminal gets, okay? And there's the only difference between county and circuit criminal is the different charges, okay? So county would be a battery, right? Unwanted touching versus a homicide. Definitely unwanted touching, and then they don't survive, right? So it's just the nature of the crime. That's what separates us. But as far as the procedure, seeing initial appearance judge, going through the formalities of an arraignment, setting things for pretrial conference and trial, it's basically the same thing. Okay, it's just the levels of seriousness. So petty theft versus a robbery. Driving while license suspended, maybe your first, second, your third, it becomes a felony. Okay, how many people knew that? Oh, you knew that? All right, very good. All right. So has anyone ever served on a jury panel by a show of hands? All right. Sir, what's your name? The nice orange shirt. Robert. Mr. Robert, so you served on a jury panel before? Okay. Did you like it? You can tell me the truth. Really? You're like the only person who's ever said that to me. Typically, people do not like to serve on a jury panel, and let me tell you, that's like my one thing that I wish I could do. It's be on a jury panel, right? Because for those of people that can't serve in our military or armed forces, this is another way you can serve your country, your community, by actually being on a jury. And I can't do my job without you all getting involved in the process and being able to sit on a panel and be fair and impartial, look at the facts, apply the facts to the law, and decide if someone's guilty or not guilty. So it's super important. So when you are selected for jury duty, please keep an open mind, because we do need you. And we love you all. So please don't give us any excuses. Come to court, because we honestly can't do anything without you all there. And jury duty is fun. You know, the attorneys might ask you a lot of hypothetical questions, but that's because they want to get you to talk to see exactly, you know, how would you handle this hypothetical? Like, what are you thinking about? You know, are you pro-state versus pro-defense, or are you really in the middle and you're just here to judge the facts that are being presented in front of you? Okay? So that's one thing I could say about jury selection. And as you know, once you go through jury selection and you are selected to be on the panel, that's when the trial begins. That's when you're going to be presented with witnesses and evidence and things of that nature. And I wasn't even clicking on here. I was just talking to you all. We talked about jury selection. Look at them. Look how happy they look. So this tells you the qualifications to be on a panel. You have to be legally qualified to serve in the U.S., be a U.S. citizen, speak, read, and understand English, have no felony convictions unless your rights have been restored, and things like that. Let's see. We talked a little bit about the trial process, and any questions? I know I talked quite a bit. Yes, ma'am.
So with the pretrial release date, we constantly see in the Orange County public records, but the courts where the courts are being registered where we can see when it is. There's a pretrial conference and a trial date. We know from experience that
It changes.
that doesn't happen with the trial. It's just being inputted as a date, I guess, for the speedy trial. But once they, so you're saying once they go to pretrial and there's a continuance of anything, then that trial will definitely go away.
So what you should see, and again, our system is called Benchmark, and Orange County's Odyssey. So I'm not sure what's image and what the public can see, but typically what you should see is a pretrial date. But prior to even seeing that date, you should see a defense motion to continue. Once in a while. But you should see that all the time, because it's important to keep a record, right? So I always tell my attorneys, like, make sure you file a written motion to continue, so we'll have record of how many continuances. Like, if you're on your third one, I'm most likely not going to grant a third time continuance, all right? It's going to have to be extreme for me to do that. But you should be able to see the motion in an order from the judge, whether granting or denying it. If I grant the continuance, then you'll see another pretrial date and another trial date. That's what you should be seeing. Okay? Yes, sir, in the back.
Earlier you mentioned that you like to add on
Conditions?
the condition that they cannot live in the same house. I wanted to know who enforces that, and is it more like bait, for instance? Like, let's say they're caught in the same home, and now they're back in court, and they've gone against your wishes. Can you then just send them straight or right back to where they came, like right to jail, or?
All right, that's a really, really good question. So with our battery domestic violence, if there's no pretrial detention motion filed requesting that the trial judge holds them at zero bond, and there's no evidentiary hearing, things of that. So let's just say there's a bond. Remember, I always say bond with PTR conditions. So PTR If they're checking in and they're staying out of trouble, PTR doesn't make home visits, unfortunately. But the way one can find out is typically my police officers will see them at a grocery store or perhaps somewhere out in the community, and they run people, and they'll know. And if, let's just say that John Doe was ran through the system, they find out that there's a no contact order, and he approaches like, hey, what's your name? Well, you know you're not supposed to have any contact. They'll basically arrest them on scene, and then the charge will be a violation of the DV no contact order. And that's a first-degree misdemeanor. I'll go through the same process. If I am the judge and I see that, remember, they're going to be held at zero bond before they come see me. I will then hear from the state whether or not they want me to issue a bond amount, but that bond amount will be substantially high, or if they want to actually go through the pretrial detention hearing and hold them at zero bond to see if the judge will also agree and hold them at zero bond pending the trial. So it's very hard to monitor the maintain a separate residence, because they don't do house visits or anything like that. Yeah, you're welcome. Yes, ma'am.
Hi, my name's Maria. I have a quick question.
Sure.
Thanks for doing this, by the way. It's been super interesting to learn and hear about what you do. You mentioned new legislation that says that someone can't pay for bond until they see a judge. Do you mind?
For dangerous crimes under that specific statute, and there's like a list of crimes.
Gotcha. Do you mind sharing a little bit more about the impact that this has had overall, that you've seen for people, but also judges like you?
I can tell you from the judge's perspective, it has increased our caseload. Typically, when you're the e-duty judge, you're reviewing these warrants, you can kind of issue a bond, and half of those cases you won't see it because they're entitled to a bond, so they'll post bond before you even see them. Now we're not seeing that. So, for a perfect example, in January, I had 150 charging affidavits mixed in with arrest warrants. I'm sure a few months ago, prior to January, it may have been 50 to 75. It has increased tremendously, but it hasn't even stopped there. With the pretrial detention motions, let's just say, so possession of a firearm by convicted felon, right? Back in the day, you could issue a bond. That person can bond out prior to seeing initial appearance judge. Now they can't, right? Because of the new statute that says it's a dangerous crime and they have to be held at zero bond until they see initial appearance judge, okay? If the attorney, the state attorney comes in and say, state, this fits under the dangerous crime statute, the state will be filing a pretrial detention motion. Please set this within 5 days in front of the circuit judge. So my circuit judge, Judge Egan, you in criminal, Judge Egan? So he already knows. So he can tell you a little bit more about that, but I'm going to assume Judge Egan has seen an increased amount of pretrial detention hearings. So sometimes they'll resolve prior, sometimes they'll just agree to an amount before they actually go through the hearing. But before, our circuit judges didn't have to hear as many of these hearings, and now it's maybe double that. What do you think, Judge Egan?
At least tenfold.
So remind you, let's just say we're today is what, Tuesday? Initial appearance. If I have 5 cases where the state's going to review pretrial detention motions, they're gonna file pretrial detention motions, I have to set each of these cases within 5 days in front of him. He has a full docket already. And there must be a hearing within 5 days.
No, and if you allow me, because this is a very big change this year in pretrial detention, which has increased our caseload. We're struggling as circuit judges. There are some crimes, as Judge Sanders-Morency said, you're not entitled to a bond when the judge signs the arrest warrant. You got to go see Judge Gabby. Burglary of a dwelling is a change. Back last year, burglary of a dwelling can really be as simple as someone stole a bicycle from an open garage.
Right.
Okay, that's technically burglary of a dwelling. Back in the last year, I'd give a bond of maybe $5,000 with the condition, don't go back there and have no contact with the victim. Now that person has to see her, and she can give a bond there. So that increases her workload. Let me give you an example. Trafficking in fentanyl. Okay, not entitled to a bond under any circumstances. They have to be set within 5 days of arrest with someone in a circuit judge for a pretrial detention hearing. Those, as well as other certain crimes, it could be manslaughter, it could be aggravated battery with a firearm. There's a whole bunch of things that they now have to have these pretrial detention hearings. And all I'll say is we now rotate, and every Tuesday and Friday, every 9 weeks, I do that, and we have 15 to 20 pretrial detention hearings on every Tuesday and Friday, whether these people should get out on bond, and I won't get into the burden of proof, but I'm sorry I talked too much.
No,
It has increased the
it's
workload
fine.
tremendously.
But this
yes.
is great because you wanted to know if the workload has increased. Absolutely, absolutely. As far as the community is concerned, I think the community is probably very happy about this. As far as certain individuals getting out on bond that really should not be out on bond, there's an extra layer of protection. So after they see me, they see Judge Egan or any of our felony circuit judges. Okay, so it does add an extra layer of protection. Yes, sir.
I had a question regarding minors, in specific to, like, as a judge, have you seen minors have you seen minors? First question. And the second question to that is, how would you approach a misdemeanor that a minor
Ooh,
offended
you
on?
asked me all the good questions. Okay, so again, I'm county, so I don't see a lot of juveniles unless it's a driving offense, like no valid driver's license. So when I see juveniles, I like to encourage my state, it's a juvenile teen court. I'm also a teen court judge. I volunteer every Wednesday night. So for cases like that, non-violent cases, I always encourage my assistant state attorneys to push that through teen court. Now, when I was the e-duty judge, I saw a lot of young people in possession of firearms. I would say 95% of the cases that I reviewed either dealt with a homicide or some young person doing a home invasion, a robbery, or something of that nature. Always violent. Now, the state attorney makes that decision if they're going to direct file, and that means that, let's just say the person's 16, 17 years old, they are a juvenile. But the state attorney can make that decision to direct file, which means charge them as an adult, okay? Now, I can't speak to that because, again, I'm in county. I don't see a lot of violent juveniles in front of me. I'm sure Judge Egan can talk about that. He was in juvenile, and now he's in circuit felony. But from reviewing the arrest warrants and things like that, it's very violent. There's no, like, little baby cases. Even though the juveniles with no prior criminal history, they are starting big and bad.
Can we change your hypothetical, though? The man in the car with the pot becomes a boy in the car with the pot? Mm-hmm. Okay, if it's a juvenile's first offense with marijuana, they're probably going to be referred to teen court, which is a pretrial diversion program. If that young man or lady happens to be on juvenile probation, they'll probably get arrested for the possession of marijuana, have to go see a juvenile judge. Okay, but very rarely does a juvenile for just a simple possession have to spend any time in what we would call the juvenile detention center. They would likely be released for a minor offense like that.
Right, but for the big offenses, they are typically detained for 21 days. There's it's the DRE, right?
Risk assessment.
The risk, so there's points, and if you score over 13 and over, it's secured detention. But let me leave this on a light note. Again, for nonviolent crimes, there's multiple programs that we have out there. I get vaping cases a lot from my middle schoolers. Um, yeah, middle school, they're vaping very young. I will send them to teen court. Sometimes the officers won't even send them to teen court. They'll just give them like a citation. Okay, that's just a warning. Okay, so they'll start off with a citation first. If you, I think it's 2 citations, then it comes to us, which means either the state or it just comes in front of me. We all make a decision whether that juvenile should go to teen court. So that person, that juvenile, has an opportunity to do better. Okay, and there's also several wonderful programs that the Ninth Circuit has. That team has drug issues, there's drug court. There's track 1 and 2, pre-plea, post-plea. There's DUI diversion programs. There's veteran court. Well, that's adults, but if you all want to set up a veterans program, which is amazing. But there's different programs out there that want to help folks out.
Now, if you don't mind, can I throw you a hypothetical? If, of course, no one has another question.
Sure.
No.
I
Well,
love hypotheticals.
hypothetically speaking, I guess more for him since he's seen it more. I'm sorry, what was your name?
You can call me Bob.
Okay, Bob. Let's say you see a juvenile and they stole a bike worth $150 and they attempted to sell that bike to an undercover officer.
Oh man, I'm thinking grand theft, stealing stolen property. Those are all felonies, by the way.
Let's say this person is 15. How would you approach it?
Well, Judge Gabby said, well, first of all, the state attorney's office will make a charging decision. I do nothing until they charge them. And if that person is eligible for a diversion, pretrial diversion program, in lieu of criminal charges, delinquency charges for a juvenile, go do this program, community service, write a letter of apology, whatever the conditions are, then they won't be charged. But if something like that is charged and comes to me, he would get in. Juveniles have the exact same rights as an adult does. Okay, they get an arraignment. They get a lawyer if their parents cannot afford one. They get a pretrial date and a trial date. They conduct discovery depositions, and then they would go to a trial. The only difference is the juvenile doesn't get a jury trial. As a juvenile judge, I've presided over hundreds and hundreds of juvenile delinquency trials, and they're awesome because they take maybe an hour. And you don't have to pick a jury. But no, it would be treated like an adult, and that case would come in front of me, and if necessary, we'd have a trial. The state would put on evidence and witnesses and things like that, and the judge would make a decision of, in that case, not guilty or not guilty, but delinquent or not delinquent. And then you would have a sentencing, just like an adult.
We work, okay. So this is a question about the attorneys that are appointed for people who can't afford them, the public defenders. This is a question about public defenders, okay? So I work with transition reentry with inmates, women, and so I often have to talk with public defenders. And so in doing this over the years, I've had concerns. I see a lot of variables, and I don't know what is the bottom line that someone should expect from representation. I mean, as a judge, sit there and you see all different things, I'm sure.
The one word that comes to mind is competent attorney.
I guess what I'm saying too is it's not just the time in trial, but can they expect that this attorney is going to come and visit them in jail? Can they expect that so if they don't do that, is that cause for a Nelson hearing or things like that? Yeah.
So, yes, if that defendant feels that their attorney is not competently representing them, don't have their best interests, yes, they can file a motion to remove that attorney.
It all takes more time and drags everything out.
No, not really. As long as they file the motion, the judge will set it for a hearing. we will have a full hearing about what, what is going on. When was the last time you spoke with your lawyer? Do you know if there's a plea offer? Were you appraised of the plea offer? I'm gonna get to the bottom of it, because at the end of the day, he has a right to competent counsel, and I have to make that determination that they do have competent counsel and they're being represented. If I do find that they don't have competent counsel, then that attorney will be removed, and then we have a list of attorneys that we can appoint.
Well, I just spoke with an attorney today that was, it really just worked for me, so that's why I'm just kind of wondering.
So now you can't file a motion.
No, no, no.
The defendant will have to.
Yes, I just, in terms of knowing what to expect, and I just felt like the attorney was acting like, he didn't, he said, I've been doing this for 20 years, I know what I'm doing, she needs to just settle down. He hasn't been here at all, she doesn't know anything. So, I don't want to get into the certain thing, but I had this question periodically.
It all takes a motion. As long as there's a motion before the court, we can set it for a hearing, and we will determine exactly what is going on. And there's never been any point, that there's been someone complaining about their attorney, we don't set it for a hearing, we just ignore it, okay? Because there's certain appellate procedures, 3.85 is one of them. We don't want to go down that line. We want to make sure that there's competent counsel all periods of the trial. So we want to make sure that this person is being represented. So yes, we will take care of it. We do not ignore things like that, especially things like that.
What determines whether a defendant qualifies for a public defendant?
It's finances.
Like
They
what?
typically will do their application and a clerk reviews it, and they have like a little cheat sheet that tells them. I can tell you one thing that will definitely like not make them qualify. If they own a house, won't qualify. Okay, things like that. But that determination comes from the clerk of court. Sometimes, I've actually not had the opportunity to review it, but for the times that I think maybe a year ago, I don't know, something was going on, and I actually had to take testimony. I will typically ask them, when was the last time you were employed? Have you made efforts to gain employment? Do you own a home? Are you renting? How much is your rent? Things like that, trying to get a financial picture in order to make that determination. But there is a statute that tells you that if you have, I should have included it, I didn't think that was going to be an issue, a question. But if it's one person in the home, you can only make this amount of money, and multiply by 33. So like it just goes, I think 1 through 5 or something like that. So it depends on that chart, honestly. Yes, ma'am.
What does EV judge stands for? I'm sure you probably mentioned it, but the words EV judge? What? ED.
Whenever I see ED, I'm like evictions. But
ED, what's the initial stand for?
ED,
ED.
Emergency duty.
emergency duty. That's what I was talking about early on, that we do this once a year for 7 days. Yes. Yeah. It's fun. Look at my face. It's so much fun. We get woken up at all hours of the night. We also work at the jail. So Saturday and Sundays we're at the jail for majority of the day. We do the juveniles in the morning, and then we go to Orange County Jail. We do Osceola County first, and do the teleconference, and then we deal with Orange County inmates. So, yes, ED. Legislative duty. Evictions. I want to know about evictions. I'm gonna tell you about evictions. Yes, ma'am.
I'm curious. I know every judge has a reason as to why they do what they do. What's your reason? Like, what makes you tick as a judge, and what are your like favorite types of cases?
So, I have been in front of maybe 20 plus judges in my career as a prosecutor. I was actually in front of Judge Egan. I don't know if you remember. my co-counsel, Dahlia Abduberry.
Oh, sure.
It's all good. But anyway, so I was in front of so many judges. Some were teaching judges, some were not. And at the end of my prosecution career, I was the deputy bureau chief. So that means I ran the Osceola County office. I was tired, honestly. I had been the homicide attorney. I was physically and emotionally drained. And I was like, do I go into private practice? Do I chase the money? Or do I want to do something that's going to be fulfilling? Something that I can sleep at night and I can still be of service to my community. That's how I ended up being a judge. Because I'm like, as a prosecutor, for so many years I did that. Served my community, protected my community, put really bad people in prison. And I'm like, what job can do that? What other job can do that? But at the next level, judge. And as a county judge, again, I'm not dealing with the worst of the worst. I'm dealing with your common citizens that just made a mistake for whatever reason. You know, maybe they were super hungry and they decided to steal that banana out of Walmart. Things like that. I get cases from Walmart all the time. They misscan items. It's a petty theft now, you know? It happens. And I think as a county judge, you have to have the right temperament for any, as a judge, period, you have to have the right temperament. But as a county judge, you are the judge of the people. Like, you see your common citizens day in, day out, whether it's a no valid, driving while license suspended, permitting an unauthorized minor to drive your vehicle, yes, that is a crime, expired tag, you know, things like that. This is stuff that I see, your common day things, and I just love it. I love it. And if I ever get a little itch to do some felony cases, I do that.
After that question, my question is, how do you decompress after seeing, a whole day of this, sad stories? How do you decompress after work?
That is a great question. We make very tough decisions day in, day out that affects people's lives. And I can only speak for me, but I run and I lift weights. That's my stress reliever. And we have a big wellness program, so we're encouraging our court staff, our judges to just get out there and take some time to decompress and take a walk. Sometimes we have really tough cases, we have to make tough decisions, and it's good to just get out of the office, take a little walk, listen to music, or maybe you don't want to listen to music. There's always something different. I know some judges take boxing, Zumba, there's just different things that we do, but it is tough. I can't lie to you. Mr. Swin.
Ladies first.
Sorry, excuse me.
Okay, all right. I'd like to backtrack to the driver that got pulled over for,
Marijuana?
okay. I want to play the role of the driver. Okay.
Who am I?
You're the officer.
Okay.
I'm not trying to demote you now. I get pulled over. Officers, I smell marijuana in your vehicle. And that's a scientific fact that cannabis and cigarette smoke can linger in clothing and apparel and upholstery in a car for several days or longer. When the officer tells me I have reasonable suspicion, in the course of handing the officer my license, my registration, I give him a copy of my medical marijuana license and a prescription from the doctor saying I'm being prescribed for a medical ailment. All that being said, what's next?
Have a great day. and God forbid, let's just say it goes the wrong way and you get arrested, okay? If it comes to me, will it come to me, Mr. Glenn? Will I see it?
Well, see, earlier when
Hold on. Answer my question first. We're going to use your hypothetical, and let's just say it doesn't go your way. You don't have a good day, and you get arrested. Who do you see? Who do you see?
from initial appearance,
Yes, you see a judge.
right? say the police, they have opportunity to collect further evidence.
Not afterwards, it has to be there. Remember,
So before I get arrested
uh-huh.
and I present all these items to them,
Remember,
why am I being arrested?
you're being stopped. You're being stopped for a broken tag light, right?
Right.
So when he approaches from using your scenario, it's just a smell. The smell is not a crime, again, right? Because it could be lingering for whatever reason, okay? Now, he smells it, but he doesn't see anything. With my hypothetical, he not only smelled it, but he also saw the butt.
Again, I have a license and a prescription.
Okay, well, putting both of our scenarios together, okay? So let's just use my scenario, but this person has a medical marijuana card.
Oh,
I've seen it where the officers will either let them go and do a notice of appearance.
if they're not impaired.
Right. Stuff, Mr. Clem, let's keep it simple. So, they get the medical marijuana card, everything is good. You're either gonna have a great night or you're not, okay? You're gonna be either arrested or they're gonna let you go and there's gonna be a notice to appear. And the great thing about our criminal justice system is someone is going to be reviewing it. I will review it as the initial appearance judge, but keep in mind, it doesn't stop with me because I am not the person that is going to be filing information, okay? I'm not filing that document that says you are being charged with whatever. That's going to be up to the assistant state attorney. Now, as a former prosecutor, I can tell you that I made that determination based upon what I saw in the charging affidavit, whatever necessary evidence. And I will have to swear to that information that I can prove this case beyond a reasonable doubt. Okay? So there is layers of protection. Okay? Now, our criminal justice system is not perfect, but it is a system that works for us because I'm sure you all know in other countries, it is far more worse. They are not entitled to see a judge. They don't have a jury or anything, okay? So, people don't always get it right, but there are layers where the room for error is very, very slight, okay? So with your situation, again, someone's always gonna review it. I'm gonna review it, and the final person that's gonna make that decision is going to be the state attorney. And if they file, that's perfectly fine, because you're gonna get a criminal defense attorney. If you have a great criminal defense attorney, they're gonna do a motion to suppress. They're gonna do a lot of things to make sure that you're able to get off.
Judge, follow up here.
I have a follow-up on the hypothetical,
Which one?
the one about the marijuana.
Okay,
It's not illegal to drink and drive. It's illegal to drink to the level that your normal faculties are impaired and then driving. Is it illegal to smoke marijuana if you have a medical card while you're driving? If the officer sees smoke when he rolls down the window and he sees the smoke coming out? Because it's illegal to be drinking while you're driving.
if we're specifically talking about impairment, I mean, first of all, the medical marijuana, listen, I'm not a scientist or, what I can tell you is that medical grade is completely different than what they're selling on OBT or anywhere else. So what you're getting on the street will probably get you impaired and get in trouble. But what the doctor is prescribing, that's different, okay? It's for pain, it's for whatever reason. It's different.
Yeah, my question basically was, if it's illegal to drink while you're driving,
As long as you're not impaired while you're driving and you're,
well, there's open container and there's the
Right,
cop sees you with
right.
a beer while you're driving.
you can't do that because that's a charge also. So what's your question?
Well, if the test is going to be impairment, though, to answer your question is you cannot be under the influence of narcotics if it impairs you, marijuana. There's no quick test like a breath test for DUI. That's quick, and you can get an answer right away if somebody is over the legal limit. But a police officer can give you a field sobriety test if he feels that you're impaired with something else, and if you fail it, you're probably going to get arrested, even if you blow what we call triple zeros on the DUI machine.
They will then
You can't be.
urine sample. So we'll know if you don't refuse. We'll know exactly what's in those concepts.
Hi, I'm full of questions. There was a slide about burden of proof, and Judge mentioned it a minute ago, and was there something with the burden of proof through all of this?
So remember I was telling you that that the cop has reasonable suspicion here to stop you, PC to arrest, right? So the burden of proof is beyond reasonable doubt for a criminal case. That's here. I wish I had a third arm so y'all can see, but you get it, right? So that's what it is. Now there's other burdens of proof. So preponderance by the evidence, that's something that I hear as a civil judge. That's their burden of proof. It means more likely than not, okay? But since we're only talking about criminal, the state has the burden, okay? Their burden is beyond a reasonable doubt, and it never shifts to the defendant. And I always like to tell my jurors, just imagine a big old rock on the state's desk. That rock does not move throughout the trial process. It does not move. You have to hold the state to their burden, and that is beyond a reasonable doubt. So let me see if I can go back so you all can see this. It's number one. See? You can't, oh, I'm sorry. So again, the very bottom is reasonable suspicion, then probable cause, then preponderance, then clear and convincing evidence, and then beyond a reasonable doubt. Okay? Preponderance, I know it's weird. Preponderance of the evidence. Okay, so if you're ever suing someone, that is the burden. Okay, so breach of contract, if you're suing someone for damages to your vehicle, personal injury, things of that nature, it is a preponderance of the evidence. That's civil. Okay, but what we're dealing with tonight is criminal, whether it's county or circuit, is beyond a reasonable doubt. Okay, and that is the state's burden. Yes, ma'am.
I have a question about evidence, actually. I'm not sure if you can answer it. It's based on, say, fraud cases. Is that something that you can address?
I used to do little economic crimes here and there. Let me see if I remember.
So I'm actually very curious. Evidence is the thing I work in. So as far as fraud cases, maybe even unlicensed contractors coming before the court, what determines what's good evidence? Let's say, for example, we obtained a copy of bank checks back in front that shows that there was a deposit, right? Is the judge, and I'm not sure if it's the state attorney level maybe, where this is being, they want instead a certified bank, bank information. What's going on there, and why is it not sufficient to have a copy of a bank check?
So we just don't want the copy because anyone can draft a check, right? So you want to make sure that check comes from a bank, and you want to make sure that bank manager, that teller, that the custodian of records is able to say that this is a true and accurate document, and they have to certify it. Because what happens if you do not certify it, the defense attorney is going to object and say that it has not been properly authenticated, so you can't bring it in as a business record, because business records have to be certified.
So that's something that's now set and understood across the board, and it's
Oh,
set by
absolutely.
judges or by the state attorney's office?
The state attorney's office should know that, but I mean, as far as the evidence code, that is a requirement.
Okay.
Okay?
Going back to Glenn's scenario, and it's not, they could go good or it can go bad. If it goes bad and he gets arrested, he's stuck in jail till the next day, right? It gets really bad for him then.
You'll see, I typically start initial appearance in Osceola County at 1 o'clock. I think, what time is lunch?
It's in the morning.
Okay, so Orange County will be in the morning, and then if he gets picked up in Osceola, it'll be at 1 o'clock. But yes, he will see someone within 24 hours. Good question. Yes, sir.
mean, you could consider this a hypothetical, I guess. This is more a question on careers. How long have you been working as a judge?
5.5 years.
5.5 years. And Bob?
Almost 16.
Okay, then I guess. Well, actually, anyone in this room with a degree can answer this question, I guess. But what degree would you recommend to someone, for instance, criminal justice, like a degree path that you'd recommend to someone who's interested in law for like 10 years down the road that you see as like a growing field that Google wouldn't say? Like, I want your in the field personal opinion.
That someone is wanting to take the path of becoming a lawyer and a judge.
Just something in the criminal justice area, actually.
I'm sorry?
In the criminal justice field.
Well, what exactly do you want to do? It just depends. Like, do you want to do forensic? Like,
More towards like the courthouse, like a lawyer.
I'm sorry?
Like towards the courthouse, like career is geared towards the courthouse.
Well, there's several.
The list, go ahead.
Clerk of court, there's courtroom clerks, there's individuals that work in accounting, there's program specialists, there's interpreters that are utilized quite often. There's so many things you can do.
If you got criminal justice, you got criminology.
Again.
So what he's asking might fall up under criminology.
Well, what do you want to do? Since you want to be a lawyer, I can see why all these hypotheticals. I always tell people that you can literally major in whatever you want to do. Honestly, you don't have to get then you don't have to get your degree in criminal justice or anything like that. I got my degree in, English and American literature, and I had known I wanted to be a lawyer since probably was like 8 or 9. So I truly believe Matlock taught me English. Right. And I was in ESOL. I don't know if you all know what ESOL is, but again, I didn't speak the English language, and it was so difficult for me that I started to stutter. So I was going through speech therapy, but also watching Young and the Restless and Matlock. So I truly feel like those two things taught me English. But nonetheless, I have been in pre-law since middle school, in high school. I thought I was going to major in political science. I kid you not, that was my major. Got to USF, hated it. I was like, this is so boring. I am not a politician. I don't like any of this nonsense. And I got into English. And I was like, ooh, I like Lord Byron and Shakespeare. And that's what I ended up doing. And even after I graduated from USF, I still took a year off because, like, is law school really something that I want to do? Because it's super expensive. I don't have lawyers in my family, And I still ended up going to law school. But everyone's path is different. You don't necessarily have to do criminal justice. You can do whatever you want. And then when you get to law school and you pass the bar, you can use your legal degree for anything you want. I have a very good friend who was in a big firm downtown Orlando. The work-life balance wasn't there. She quit that job and became a dean at a law school. And now she left that job. Now she's working for a nonprofit organization. I have another friend who's in-house counsel for State Farm. I have another friend who's a law school professor. I have another friend who's not in law at all, but has a law degree. So you can go into education, you can do sports, you can do whatever you want with your law degree, honestly. Okay? That's the great thing. It's a huge field.
Can you help me thank Judge Sanders?